special edition of the Queen's Grapevine. This is your host, Wallingford Lee. Tonight on the Queen's Grapevine is an episode about sexual harassment. A lot has changed, obviously, since the rampage age to the wild man behavior in the office of harassing women all over the place. Today we have a better education situation where we know what is right and what is not right and how to treat a woman with respect, and we should, because she truly deserves the respect. No woman should be harassed at the workplace or anyway. So we just feel that talking about sexual harassment would be somewhat of an educational situation in a program of this magnitude. And more important, we want to talk the legal aspect of it. We want to talk a little bit about how the Supreme Court also view it. We want to talk a little bit also when we talk about sexual harassment, how it's perceived from the different race, the Latinos, the blacks, and also the white. Because sexual harassment is a very, very sensitive matter. Well, we have today our special guest, a person that's been on our program before, and it gives me a great deal of pleasure and, of course, satisfaction to have Professor Tanya Hernandez again on our program. She has been so kind enough to accept our invitation again to be on the program to discuss something as sensitive as this. Welcome to our program, Professor Hernandez.
Thank you. It's lovely to be back.
Well, it's always a pleasure to work with you. As I told you before, we got a ton of calls in Westchester and also in Queens on the program that we did before about when we talk a little bit of racism, stuff like that. This is a little different topic. The government seemed to feel that sexual harassment is not as rampant as it used to be. Is that accurate?
Sexual harassment in the workplace is an ongoing and continuing problem. After 1991, Title VII of the Civil Rights Act of 1964 got expanded and enabled people who are victimized of other forms of discrimination, not just sexual harassment, but if they're discriminated in the workplace, to be able to file lawsuits in which they could seek compensation and not simply reinstatement. And so this has enabled more people to have an opportunity to be able to have the resources to file a complaint.
As we talk about it, and we'll come back to the law, as you mentioned, but just exactly, for a viewing audience, just exactly what is sexual harassment and what is the interpretation of sexual harassment?
Sexual harassment, as understood by law, right, because it's a legal claim, is a form of gender discrimination in the workplace. And the way it is a form of gender discrimination in the workplace is where there are unwelcome acts of sexual conduct that alter the working conditions for an employee. Such that it is severe and pervasive and changes what it is for them to be in the workplace, meaning that they're not treated as an employee, they're being treated as if they were simply an object for sexual entertainment or gratification.
When we talk about sexual harassment, again, we mentioned it's a sensitive issue, but we have to look at both sides of it. Is it conducive because of the behavior of how certain women dresses in the workplace? I mean, I'm not trying to say that will give a man the right to do it because it's wrong. Does that bring on a problem because of the dress, the way how certain women dress at work?
Well, what we have seen in the ongoing research into the occurrence of sexual harassment is that it is pervasive, that it is across all occupational sectors, that it does not know a preference for any particular age or employment status, and also that the mode of a woman's dress doesn't alter or make her more predisposed to occurrences of sexual harassment. That is a stereotype that is quite pervasive. It's also a stereotype that has been infused into our understandings of rape, that women have welcomed rape because of how they've been dressed, and we've tried to reform rape law to correct that misunderstanding. But it's also infused itself into judicial understandings of sexual harassment, such that even though sexual harassment is understood as unwelcome, sexual conduct that changes the working conditions for employees, the examination of what is unwelcome, courts allow in questions about how the employees spoke about sex in the workplace, how they dressed, whether they were sexually provocative, as if that has anything to do with someone harassing them in the workplace. So it's not supposed to be, but yet you still see a part of the...
Still goes on.
Yes.
How intimidating is sexual harassment today?
When you say intimidating, do you mean is sort of how frequent it is?
Yes.
Or, well, we have actual documentation that the EEOC, the Equal Employment Opportunities Commission, keeps statistics and has shown a rise in the number of reports of sexual harassment over the years. And certainly the current studies about the military shows that sexual harassment is a problem that we have not yet found a way to completely resolve.
It's ironic that you would mention in the military. You know, I read a couple of articles in the New York Times, the amount of young women being raped in the military, and what a hush-hush situation it is. How they are harassed, not only by captain and sergeant, but also by the common young men that just joined the army. I couldn't believe how widespread it is, and what a terrible situation, and how intimidating it has to be for a young lady who just left her home to go serve our government in the military, and to go through something so barbaric and so terrible. It's an awful thing. And I don't think a lot of it that goes on in the army comes out the way it really should, because I'm quite sure it's very hush-hush and very terrible.
Well, I think that the military is an extreme example, but yet just another example of a particular pattern in the workplace, meaning that the actual rate of victimization of working people, women in particular, but men are also subject to sexual harassment, that the rate of harassment is much larger than the number of people who actually come forward and report. There is still a great taboo about this form of victimization, and also a real sense of fear about retaliation. You know, that speaking aloud about it, giving voice to what has been problematic, turns around and further harms the actual person who's been victimized. And so while the military, the news about it has been showing us some very sort of extreme examples of harassment that sort of ends up being actual forms of rape, forms of physical sexual abuse, it is not, unfortunately, aberrant.
Why would it be, in some cases, women refuse to divulge the sexual harassment? Is it fear from their bosses or other issues?
It's a very sort of complex backdrop to why many women and men as well won't file complaints even though they feel they have been seriously harassed. I think probably one of the most predominant of the reasons is they fear not being able to find employment after they get fired. Right?
Wow.
And it's a very real fear that supervisors will find other devices to have them pushed out of the workplace for being troublemakers, for raising the complaint about their inappropriate treatment at the hands of the workplace. And so the more vulnerable the worker, linguistic minorities, non-documented workers, they are particularly prone to victimization because they are less empowered to file a legal complaint.
And the fear also. When we talk a little bit about sexual harassment, I remember one of a big case that came to the Supreme Court was Meritor Bank versus Winson. Can you talk to us a little bit about the impact of that particular case, the racial connotation of it, and also the rampage of how it was received, A, in public, B, in the Supreme Court level?
Well, in 1986, the Supreme Court issued this decision, Meritor Savings Bank versus Vincent. And what was significant about the case is that up until that time, there had been a few lower-level district court cases, trial cases, that had raised the question about sexual harassment being a form of gender discrimination, but it was only in 1986 where the Supreme Court issued an actual decision that stated unilaterally, yes, indeed, sexual harassment is illegal. Sexual harassment is a form of gender discrimination. So it's quite a significant case for making a very clear-cut statement of recognizing sexual harassment as a form of gender discrimination.
So obviously it had a very impact when it hit the Supreme Court in more ways than one, and it also was a big eye-opener to the public in general.
Oh, most certainly. And with that decision in 1986, that enabled more women, now that they had a clarification and a delineation of, a definition of sexual harassment being unwelcome sexual conduct that changes working conditions. This enabled more women to be able to both recognize what was happening to them as illegal and not just a bad experience, and also enabled their lawyers to have a way to actually bring it to court because they had clear-cut definitions that the Supreme Court provided.
And more importantly, it gave them the confidence to know that they could come forward if they have been sexually harassed. Are there a lot of widespread situation on the other side of it where men are sexually harassed by women on the job?
Most definitely. Men are also subject to sexual harassment. And a same-sex sexual harassment case actually was brought before the Supreme Court after Meritor, a case called On Call. And in that case, it was a group of men working on an oil rig out in the Gulf Coast.
Wow.
And a man who did not identify as being gay, but was viewed by his co-workers as more effeminate, was targeted and subject to horrendous forms of sexual harassment and physical abuse. And the Supreme Court saw that and said, this is not a problem that's only about women, although we do see that it's a primary device used by supervisors and co-workers to try to exclude women from the workplace. Let's be very clear about what sexual harassment is. It's not sort of bad forms of overture for asking for dates. These are people in the workplace who don't think that women should be there or that effeminate men should be there. And it's a way of trying to discipline them and give them the very clear-cut signal, you don't belong here as an employee. You can't contribute here in the same way that straight men can, or very masculine men.
It's a terrible thing. When we get back on the Queen's Grapevine, we'll continue talking to Professor Hernandez about various issues about sexual harassment, and more importantly, the right as a human being where you must not, and under no circumstance, tolerate it. And also the divided and small line between actual sexual harassment or asking for a date or what is appropriate and what is not appropriate. We'll be right back on the Grapevine as we continue navigating about sexual harassment. And we're back here in the Queen's Grapevine talking about sexual harassment. It's a very sensitive matter that affect our daughters, our nieces, and even our mothers in certain circumstances. It's a very widespread thing. Today, the government seems to think that sexual harassment has not taken up a big page like it used to because of great education that is out there about the do's and the don't. But I tell you that it's a silent thing that affects women, and it's very disrespectful to them, and it should not continue. And as a human being, you have right to work on a job. You're there to do your job and to complete your job, not for sexual advancement and stuff like that. So again, it's important that when you look at a program of this magnitude, you have the opportunity to know the certain amount of rights that you have as a human being and how you should be treated, and the responsibilities that you have to comply with as a worker, and that's your extent. It shouldn't be sexual favors. Well, one of the things I want to talk about a little bit for a few seconds is Women on the Law. This booklet here, more or less, I know there are a lot of attorneys that contributed to this book. What are some of the things that are in here?
The book Women in the Law Stories is an anthology, a collection of stories by other legal academics, all about the way in which women are affected in law and various cases that have been important in advancing women's rights and equal opportunity in law and in society for women.
You did have some contribution here also.
Yes, I contributed a chapter all about sexual harassment and women.
Excellent. So I I would say to you, if you get an opportunity, jump on this. There's a lot of important things, here that cover women's rights and pros and cons. Woman and the Law Stories. Very interesting booklet. I can assure you that. Professor, one of the things I want to go back to is the Meritor Bank case. Part of the things that I read, it leads me to believe it was a little bit of a racial silencing. Can you touch on that a little bit?
Well, what's so fascinating about the case is that, as I said earlier, it's a very significant case. It's the first time that we have a clear-cut statement from the Supreme Court letting the entire legal community know that sexual harassment is a problem. It is a form of gender discrimination as an illegal. So that's an important thing to keep in mind. But what is somewhat disturbing about the case is that it lets in some aspects of racial stereotyping that are completely unnoticed because the court does not state at any point in time the racial identities of the players in the case. The woman who was...
They just touch on the case only. They
don't
just
talk about it as if it were a race-neutral context.
Globally.
And in particular, and in this particular context. And what that overlooked and the reasons why it was problematic, let me sort of lay out for you. First, it was a black woman who was the victim. Second, the person who attacked her over a 7-year period of time was a black man. He also did the same form of victimization to all the other black women that he hired. And this was a bank, a local community bank in Washington, D.C. And so he had this pattern of seeking out vulnerable young black women to employ as bank tellers, and then using his position as supervisor to exert control over them and make sexual demands of them and to actually rape them. So, this was a real bad guy.
Wow.
Yes,
wow.
Indeed. Now, you may say to me, well, isn't that a problem no matter what the race is of the person? Certainly. It is no less illegal because these were all black players involved in the context. But what I think is problematic about being completely silent about the racial identities of the participants is that then when there are these racial stereotypes that sort of get put into the case, the court seems almost unable to recognize what's going on because they've been so race blind in their entire analysis. So for instance, in the case, there's this whole question about, well, she worked there a long time and didn't raise a complaint. She didn't bring a complaint to her higher-ups.
Until now.
Until later, because she was so afraid. And actually, a little footnote here, she didn't even know that this was a form of illegality in some respects. She doesn't go looking to file a claim. She only learns about her claim being problematic when she seeks a divorce attorney, and during the interview with her divorce attorney breaks down in tears, sort of like all the stress that she's been going through. And the divorce attorney asks her what's going on. She explains what's been happening at work, and the divorce attorney says to her, you need to see an employment lawyer. Oh. This is a problem. Okay, so why is it a problem, this racial silencing? In the course of the proceedings, the issue gets raised, well, she didn't raise a complaint, and the supervisor says that she was dressed provocatively and was very sort of sexual, and so it was welcome. It was voluntary. And the court, while saying issues of voluntariness should not be the way to decide this, because if you are a subordinate and your boss is asking for things, the actual saying yes, the language of saying yes is not a true indicator of whether this was unwelcome because they hold so much power over you. So we shouldn't look at this as being voluntary in whether you said the word yes. We should look at whether or not it was actually welcome. Cool. But in looking then at the details in deciding is something welcome or unwelcome, the court allows in these stereotypes about black women being overtly sexual into the legal analysis.
Wow.
Right? So they're race blind, but their race blindness doesn't enable them to then actually be able to recognize when problematic racial stereotypes are being imbued into the actual legal standard. And so this is why I think it's so problematic that, while it's a case that should be celebrated, don't get me wrong, I agree it's important that we have this decision that is clear cut about saying sexual harassment is a problem and illegal. The articulation of the standard for it lets in some very disturbing racial stereotyping that now affects all women regardless of race, right? So all women, and white women included, are now put under the burden of this standard that says it's okay to ask them what they were wearing and what they were talking about to assess whether or not the sexual harassment was welcome.
Or it did occur.
That too.
Yeah. It's interesting that you would mention something like that. Our research shows two different type of things, and I know you did a great survey, and I want to get to that. I don't want that we don't get a chance to talk about. Our survey shows that a little bit that there is a connotation or a belief that women that has melanin in their skin, whether it be Latino or black, tend to bring more racial, more sexual harassment cases up front. And it also shows that white women, when they bring a sexual harassment case, they're paid more attention to by their bosses in most cases. Is this accurate?
Well, what's fascinating here is we have a number of layers of stereotyping and some misperceptions all going on at the same time. So with regards to who is more prone to bring a claim, we actually see that when it comes to going forward about what they think is sexual harassment, that women who are interviewed, white women, have a much broader range of actions that they view as sexual harassment. I mean, they have a bigger box of items that they would count as being sexual harassment, whereas women of color, and black women in particular, have a very narrow field of what they view as sexual harassment. Like, it has to be severe, almost bordering on rape, before a woman of color will think of it as sexual harassment worthy of bringing a claim. Right? So their definitions are distinctive, given their history and, I think, perceptions about whether they think the workplace is going to be hospitable. Right? So that women of color actually think the workplace is going to be hostile, and so they have a narrow perspective of what they view as sexual harassment. That being said, though, we still see a disturbing pattern. You were asking me about the survey.
Right, because of the racial disparity that comes along in all of these issues, and there's always tend to be a racial disparity in these type of situations.
Well, what I found in a survey of working women in the New York City metropolitan area is that the white women who I surveyed were more prone to bring a claim to their supervisors, were more prone to bring a claim within the workplace. Okay. Whereas women of color were not believers in the internal complaint process. They had more fears and greater concerns that it would not be a fair process, and so the women of color would go directly to the EEOC to file a claim. Now, what's interesting here, though, is that we still see that women of color, although they represent a smaller portion of working women in the workplace, in the labor market, you know, let's say roughly grouping them all together, they are more like, shall we say, 20% of working women. They file claims in greater proportion than white women do. Exactly. Even though white women are, let's say, roughly 80% of the labor market of working women. And so we see a racial disparity in their greater presence. Even though they have a narrower definition of sexual harassment, they're still bringing disproportionately more claims compared to their presence in the workplace, which seems to suggest something race-based is going on. We don't have all the details, right? Because this is a hard area to research. Is it because they are being targeted more? Is that what's going on? Or is it that the forms of sexual harassment they experience are so much more severe that it then motivates them to bring claims more directly and more frequently to the EEOC? But we don't have all the answers here, but we have the beginnings of questions that need to be further researched about the ways in which sexual harassment does not seem to affect all women in the same ways across race, even though it is an equal opportunity form of victimizing women in the workplace. So that, for instance, there's lots of research about women professors. You would think women professors are in control, but how they are sexually harassed
Wow.
by their students and coworkers. And so it's not something that we can say is only in one part of the occupational field.
Wow, very, very sensitive and very, very troublesome to a certain extent. How long did it take you to put together your survey?
Well, I was very fortunate in that I was able to work with a group, a nonprofit in New York called Citizen Action Center that runs a hotline to a Working Women Center. And what they enabled me to do was be able to have these women fill out these forms anonymously and voluntarily.
That's the best way.
Yeah,
That's
so
the
that
best
over a year's period of time, I was able to send out 1,000 surveys and have the women let me know with their anonymity intact, because the center fielded it for me, what their experiences were in the workplace as far as being exposed to sexual harassment.
Well, Professor, time has gone on us. We want to take this opportunity on behalf of the family of the Grapevine to thank you so much for allowing us to have the opportunity to talk to you about sexual harassment, which is something that affects a great deal of the people out in the community there, and it's a very sensitive issue and very delicate. We don't have words to thank you for that.
It's my pleasure to be here. Thank you.
In behalf of the family of the Grapevine, I just want to say to you that you have rights. You should not tolerate sexual harassment. It's not a good thing. It could be intimidated, but you have right. Again, this is Wallingford Lee saying to you, thank you for watching our program. We hope to see you next week at the same time, the same place. Good night.